Good evening, everyone. How are you? Yes, I'm fine. Yes, thanks a lot. Thanks a lot. So, I hope I am audible and visible to you. If I am not audible or visible, kindly let me know. Okay, I think I am audible and visible to everyone. Now, let's start. Look, today we have to discuss obviously IPC, but in this we have to discuss first unnatural offenses, then it's adultery. This is section 377, and this one is section, tell me, 497. Okay, so let's first discuss unnatural offenses. It's a very small topic, and basically I would be discussing judgments. As you must be knowing that this one is already overruled in the case of Joseph Shine versus Union of India, and this one is also partially overruled in the case of Tej Singh Johar. Okay. Yeah, I will be giving the citation as well, no doubts. I have written the citations and I will be providing you the same. Okay. Now let's start with unnatural offenses first. Three 77. Let's give a bare reading to it. Look, here we have unnatural offenses. Okay. Section 377 talks about unnatural offenses. Now, what does it tell us? Whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with imprisonment for life, imprisonment of either description for a term which may extend to 10 years, and shall be liable to fine. That's all. Thereafter, they have mentioned penetration is sufficient to constitute the carnal intercourse necessary to the offense described in this section. Now, as I told you, this section has not been overruled. Okay. But this section nowhere talks about consent. Like we talked about that it in section 90 consent is defined and it finds its place in various provisions of IPC. Even in section 376 we read that which was 376 secondly they have clearly mentioned that if a man does any of the acts which are mentioned there and the first is uh, there is one firstly, then there is secondly, and secondly talks about without consent. Okay, guys, I'm not discussing 376 right now because the thing is unnecessarily the course duration and the class duration will increase and many of you will stop joining or rather leave in between. So better to keep it short and crisp. Okay, it is better for you as well as for me. No doubt I can discuss the same, no doubt upon that, but maybe some other time we'll have a session on it and we'll discuss what section 376 basically talks about. Okay, they have given 376 is punishment for rape and 375 is defined what is rape. Look, 375 rape. Man is said to commit rape if he does this, this, any of these four against her will without her consent. So they have mentioned that these are the circumstances or descriptions wherein this act should be done, and only then it will constitute rape. If done with consent, it will not constitute rape. Okay, it has to be without consent and against her will. There are other descriptions as well, which basically they have basically again defined consent here. What we read in section 90. Look, if I'll just explain it very quickly, they have just again basically reiterated in some other language what we read in section 90. Okay, here. Thirdly, without her consent, when her consent has been obtained by putting her in fear of death or of hurt. We read that section 90 consent is not a valid consent if it is induced by fear of death or misconception of fact, right? Then with her consent when man knows that he is not her husband, that her consent is because she believes that he is another man to whom she is or believes herself to be lawfully married. We discussed the example wherein the lady got married in a village and a person C got into the room of the lady and had sexual intercourse with the lady, and he misrepresented himself as the husband of the lady. Earlier it used to happen. Nowadays it is quite a difficult situation. But yes, maybe in some remote areas of India, still this kind of practice may be followed, wherein the woman is or the lady even does not get to see her husband before marriage. Okay, then with her consent, when at the time of giving such consent, by reason of unsoundness of mind or intoxication, we talked about that unsound consent of unsound person, that was in second para. Then it was first it was mentioned consent of unsound person, then it was consent of child, which talked about consent of a minor, which is a person who is below 12 years. Then sixthly, with or without her consent when she is under 18 years of age. Okay, then seventhly, when she is unable to communicate consent. Then explanation for the purpose vagina shall include labia majora. It is basically outer part of vagina. Okay. This thing is done. Consent means an unequivocal voluntary agreement. Keep this in mind. unequivocal voluntary agreement. Consent means unequivocal voluntary agreement. Then that's all. This was the definition of rape. Okay, in 376 punishment, if you go to the punishment section, in punishment there are various situations given, and if the man is fits under one of those situations, then it is basically gets graver. If some person is known to the lady and he commits rape, if he is the the lady or the woman is actually below 18 or 15 years, below 16 years as well. If the person who has committed the offense is in lawful custody of the child, or if he is a police officer, or he is a police officer in army. So these, if he is a army officer. So these are the various situations which have been described in 376, and then 376 A, B, C, D, 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 A, D, B. Okay, so these were the situations. I won't be able to discuss 376 in detail, guys. I'm really sorry. I will surely, but maybe some other day. Let's finish the agendas for today. Thereafter, at least our course will get summed up, right? We need to complete our 7 day course. So let's finish off the 7 day course. Thereafter, if time permits, then I can discuss 376 as well. Look, 376D talked about gang rape. Okay, these are because of the these were added after 2013 Nirbhaya case. Okay, now let's come back to unnatural offenses. 377. Okay, so let's give a direct reading to it once again. What section 377 talk about is unnatural offenses. And what does it tell us? Whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with imprisonment for life, or with imprisonment of either description for a term which may extend to 10 years plus fine. Okay, so punishment they mentioned is either life imprisonment or 10 years plus fine. Done. Now let's break up this, and I'll explain you what the various terms of this section mean. Okay, so firstly they say whoever, not an issue, it can be any person, has voluntarily, just a sec, voluntarily, then carnal intercourse. What do you mean by carnal intercourse? Basically, it means physical intercourse. Okay, then against the order of nature. What is against the order of nature? What is the order of nature? Tell me. We'll talk about against the order of nature in a while. What is order of nature? Order of nature basically, theologically, or according to Indian society, it means penile vaginal intercourse. Okay, anal vaginal intercourse is basically order of nature, and it is done in order to procreate children. Okay, now they mention any man, woman, animal. So they did not mention about transgender, no mention of transgender, but purposive interpretation will give a purposive interpretation to it and will include transgender as well. So if someone has carnal intercourse with a transgender without his or her consent, then he will be punishable under 377. Okay. Now, yeah, they mentioned punishment 10 years plus fine. Okay. So this was a breakup of section 377. Now, on the face of it, you will find no, as in uh, uh, difficulty or problem here, but there was a problem, which is somewhat underlying problem. Okay, and it did not mention about consent. Consent is not mentioned anywhere. What about consent? If the unnatural offense or a carnal intercourse, unnatural offense, carnal intercourse basically. Okay, if this is done by two adults in room, that is a private place, then what what is the problem? There is no problem. I don't think anyone should have any problem. They are within their rights, right? They have not committed any offense. But earlier, even if they were two adults who had consented for the intercourse and they were doing the same in the private place, that is four walls of a room, inside the four walls of a room, then also it was made punishable. So this was the problem. It was found to be unjust and unreasonable. Okay, now I'll explain. Look, if A is a male, both are male, and B is also a male. LGBTQ, okay. You don't know LGBTQ? LGBTQ. It is basically lesbian, gay, bisexual, transgender, and queer. And there is one more, 2S, that is two spirited. Okay, so it is basically LGBTQ2S. Lesbian, gay, bisexual, transgender, queer, and two spirited. This is what the full form of LGBTQ is. Okay, now suppose they are, as we talked about, they are gay. Okay, they are two males and they had sexual intercourse. Both of them are 18 plus. Okay, both of them are 18 plus and they had sexual intercourse. Now, what is the problem here? They did not offend anyone's right? They did not. Did they commit any crime? Is it a crime? If they both love each other and they had sexual intercourse with each other with consent is also there, then is it a crime? Supreme Court held that no, it is not. Okay, but Section 377, to the extent that it punishes two consenting adults, that is 18 plus, two consenting adults having sexual intercourse in a private place. They have they have basically held Section 377 to the extent it punishes this situation wherein A and B consented, they were adults, they had sexual intercourse in a private place. So, to the extent of this, Section 377 is unconstitutional. What if one of them did not consent? If no consent, Section 377 is still there. Person will be liable under 377. Okay. Okay, someone is saying why can't he made liable in rape? Because the definition of rape in the first line says section 375. It uses the term man who does the things which are basically talked about in 4A, B, C, D. So these all situation 4 things can only be done with a woman. Biologically, these things can be done with a woman only. Okay, so this does not fit in the definition of 375. Now I'll discuss a case. All of this, whichever I have, these things which I have discussed, these were discussed in. Tell me. Look, there was a like series of cases. So first case which was before the Delhi High Court. It was before Delhi High Court. The name of the case was, yes, it was Nas Foundation versus, since it is Delhi High Court, it cannot be Union of India. Remember, I told you, and it was filed for the first time here. Okay, Government of in City of Delhi. Judges were Justice Muralidhar and Justice A.P. Shah. It was a two-judge bench of Delhi High Court, DB, Division Bench. Okay, Justice Muralidhar is currently serving as the Chief Justice of Odisha High Court, though he has been transferred or his transfer application is basically pending. So he is currently, or what I'll say, he was serving as Chief Justice of Odisha High Court. So it is somewhat other thing. Let's talk about, yeah. So in this case, basically for the first time, this issue of 377 was raised, and the Delhi High Court, whatever points I discussed just now, the all those were held here in this case, and they declared Section 377 to the extent that it punishes two consenting adults having sexual intercourse in a private place. It to the extent of it punishing them. It basically declared 377 to be unconstitutional, only to the extent of it punishing two adults consent. So these are the three ingredients which has to be there. Private place. Okay. So these were the three ingredients which were culled out by the Supreme Court, oh, by the High Court in this case. Though the same points were reiterated by the Supreme Court in Navtosh Singh Johar case. And in Navtesh Singh Johar, it was basically okay. Navtesh Singh Johar was in the year 19, right? Navtesh Singh Johar was in, no, it was 2018. 2018. Okay. Yeah, there were many problems. Like someone is asking what were the problems. There were many problems. First problem I told you that it basically is unjust and unequitable and unreasonable if you are punishing two consenting adults who are having their personal affairs, whatever it may be, inside four walls of a room. So why to punish something which is basically not affecting anyone and is not affecting anyone in the society? It is between two persons only, and that too with consent. So why to punish it, right? So in Delhi High Court judgment, that was this Nas Foundation judgment. One more point was held was it was that constitutional. It was held that constitutional morality is above social or social or there was one more point. Yes, this was the point. The constitutional morality is above social or, tell me, you guys tell me, social or, yes. After this, after after the this Nas Foundation case, there was another case, Suresh Kumar Kaushal case, wherein this case was overruled. That's why after this we went to Supreme Court, right? Suresh Kumar Kaushal. Yes, it is social or religious. I mentioned in the beginning, right? Theologically, it is not correct. unnatural carnal intercourse, theologically against the order of nature. When I discussed against the order of nature, what was this? Order of nature is something which is theologically correct. Against the order of nature is something which is theologically incorrect. Theologically basically means religious. Okay. So constitutional morality is above social or religious morality. This was held in Delhi High Court case, Nas Foundation case. Okay. Thereafter, this case was overruled as told by one of the participants. Yeah. So this case was overruled in Suresh Kumar Kaushal versus Nas Foundation. Okay. And here it was Singhvi Justice. It was in the year 2013. In the Nas Foundation case, the Nas Foundation versus Delhi State of and City of Delhi was 2000. Tell me, it was, how can it be 2015? It was overruled in 2013, na? I also forgot it. It is the Nas Foundation case was 2009. It was basically 2008, but the citation says it's 2009. So remember 2009. Case was though decided in 2008. Okay, maybe in the month of December it must have been decided, and it was published in 2009. That's why they mentioned citation to be 2009. Okay. Now, okay. So basically, what this case did was it basically overruled the Nas Foundation case. Nas Foundation versus State of NCT of Delhi or Government of NCT of Delhi. They basically overruled it. Nas Foundation 2009 overruled. Okay. Then the matter went to Supreme Court, and we got our famous case called Navtej Singh Johar versus, no, it's not Union of India this time. It's Ministry of Law and Justice. Okay. Yeah. Yes. Yes. Look, what happens is basically the ministry or the or various ministries are part of in India only, right? So you can write Union of India as well, no issue. Like it will be like Union of India through Ministry of Law and Justice. Okay, and it was 2018. Judgment was delivered by Justice Deepak Mishra. Rather, he was the Chief Justice at that time. So in 2018, what happened was Kutta Swami judgment was already there. Okay, you know Kutta Swami judgment? Yes, Kutta Swami versus Union of India, 2018 Supreme Court by Justice T.Y. Chandrachud. Basically, we can say it is upon right to privacy, but it mentioned about various other things, and it was a nine judgment. Okay, it is basically about right to privacy, but it talked about various aspects like individual autonomy, individual autonomy. Then it talked about sexual autonomy. Then basically in this judgment, what happened was the Supreme Court, through Justice D.Y. Chandrachud, increased the ambit of right to privacy. So what happened was that there was a, we can say, a new perception. We can say there was a new perception of how the privacy or the how the interpretation of constitution will be done. Okay, so or should be done, right? So after this judgment, you will see that almost every judgment is in line with the individual autonomy of the individual and not the religious or societal society's perception and all those things which were, no, they, no doubt that they are a inevitable and inseparable part of Indian society, but the Supreme Court in its judgment mentioned about individualistic approach rather than societal approach. They said that individual approach or the individual autonomy should be above the should be above the society, and it should be given more preference as compared to the social or the religious beliefs, right? So in basically Putta Swami also talked about this sexual autonomy and other things, and they could have overruled it in here only, but the issue was not directly in before the Supreme Court in this case, so they did not talk much about this thing. Okay, so this was the history of 377, and in this case, basically the NAS Foundation case, all the points of NAS Foundation, the Delhi High Court judgment, 2009, were upheld. Okay, all those points were upheld, right? Now, if anyone has any doubts, please ask me. Otherwise, I am over with 377. There is nothing more to be discussed here. Just remember in 377, just remember these three things. First, two adults. Second, consent of both. Third, private place. If any of them is missing, 377 will apply. If all of these are present, if all of them are present, section 377 will not apply. That's all. Just remember this thing and it will be done. Now, Let's come to 497. Adultery. Always remember Joseph Shine case. Joseph Shine versus Union of India. It is also 2018 Supreme Court. Okay. Now, what does section 497 talk about? It basically talk about adultery. That is A, B, husband, wife. Then there is another, maybe C. C is a male. If he has sexual intercourse with this wife of A, B. Okay. If C has sexual intercourse with B, that is wife of A, then A will get the right to sue C. Okay. Basically, this was the whole concept. But if A consented to this sexual intercourse, if A consented, not B, it, they are talking about consent of A, husband. A consented, sexual intercourse, then no offense. Okay. Another situation, there was one more situation. Let me draw it again for you. There is A, B, husband, wife, and there is C, D. He is husband here, H1, W1. Okay. Now, if B and C have sexual intercourse, then, and it was without consent of A, then A will get a right to sue C. But what about D, W1? There was no provision. W1 cannot proceed against B, that is W. H can proceed against H1 allowed, but W1 cannot proceed against W, not allowed. So don't you think it is unjust and unequitable? It is basically uh, what we say, a discrimination on the basis of sex, right? So this was the problem with adultery, 497. Now let's read 497 once, though it has been overruled, but let's give it a reading. Look, 497, adultery. Whoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man without the consent or connivance of that man. Which man? This man, the man of wife. Okay. Such sexual intercourse not amounting to the offense of rape. They have clearly mentioned not amounting to the offense of rape. What does this imply here? The sexual intercourse not amounting to the offense of rape. It implies that wife consented, because if it would have been without consent of wife, then section 376 would have been applied. 375, punishment 376, right? So wife consents. That's why they have mentioned that not amounting to the offense of rape. Basic. So by this we can make an implication, or this necessarily implies that 375 and 497 are mutually exclusive. They cannot coexist, right? If there is 375, there cannot be 497. If there is 497, there cannot be 375, right? They are mutually exclusive. Mutually exclusive. Both of them cannot exist together. Now, is guilty of the offense of adultery and shall be punished with imprisonment of either description. I told you yesterday what is either description. The descriptions are basically the imprisonment is of two types: simple, rigorous. Okay, so the court may award any for a term which may extend to 5 years, or with fine, or with both. So punishment given under adultery is which may extend to. So it has to be less than 5 years, or with fine, not and here, or fine. Simple fine will also do, or both. Now this will depend upon facts and circumstances of each case as to which punishment will be awarded. Right? Now, in such case, the wife shall not be punishable as an abettor. This was also a problem, that she was also not made punish. She was also cannot be prosecuted as an abettor. So let's come to 497. Okay, whoever has sexual intercourse against wife with the wife of another, with wife of another, without consent of that man, adultery. So they mentioned without the consent of that man. Don't you think it basically this provision is treating women as what we say in the words of Supreme Court, chattel or property of the man? That wife is the property of man. Because if the husband has consented, then the wife may have sexual intercourse, otherwise not. So this was held in the case of Joseph Stein versus Union of India, that this provision basically treats women as a chattel of husband. So again, Putta Swami judgment was there. Putta Swami judgment was there. Talked about individual approach, sexual autonomy, etc. Right? So in order to be in line with Putta Swami judgment, it was a 9 judges bench. These were 2 judges bench. 2 judges or maybe 5 judges bench. Yeah, Joseph Shine was 5 judges bench. Okay, they cannot go against the Putta Swami judgment or against the spirit of Putta Swami judgment. So here also they held that adultery should not be an offense and held it to be unconstitutional. Okay, one more provision was talked about in this case, and it was section 198 to CRPC. Section 198 to CRPC. They talked about this section also. And what does this section tell us? Let's see. Look, prosecution of offenses against marriage. Okay, for the purpose of section 1, leave this, read from here. No person other than the husband of the woman shall be deemed to be aggrieved by any offense punishable under section 497 or 498 of the said code. Okay, 497 is adultery. Adultery. And what is this? Tell me. It is basically enticing or taking away a married woman. We talked about kidnapping and abduction yesterday, right? So it is basically the 361 and 362. 362 talks about abduction. 361 talks about kidnapping from lawful guardianship. 361 talks about kidnapping from India, and 359 states that kidnapping can be of two types, that is kidnapping from India and kidnapping from lawful guardianship. So basically this is in line with those sections. The spirit of those sections apply here as well. Okay, now let's come to 497 again. So this, here they have clearly mentioned that no person other than the husband, they are not talking about the wife. If both the couples were married and the wife of one and the husband of another did had undergone sexual intercourse, then the husband will get the right to move right to file a case against the husband, but the wife won't get a right to file a case against the wife of another with whom her man basically committed the offense. So this was thought to be unconstitutional, unjust, and unreasonable, and against the constitution. Hence, they declared 497 as well as this. That's why they have mentioned it in red. That's why SSC people have mentioned, like highlighted it in red, because this has been overruled or held to be unconstitutional. So 497 now as a whole has been declared to be unconstitutional, and now there is no such thing like the offense of adultery. There is no such thing like the offense of adultery, but there is a thing which is adultery is also a tort. Adultery is also a tort. Okay, so you can claim damages. Moreover, it can become a ground for divorce as well. Okay, it can become a ground of divorce as well. What the wife or the husband can do, they can desert the other spouse, and in such a case, no restitution of conjugal rights will be awarded by the court, and they may file for divorce. Okay, so adultery is no more an offense under IPC, but these things still remain as it is. Okay, so this was all about unnatural offenses and adultery, that is section 377 and 497 respectively. If you have any doubt regarding anything right from the first class till the uh, last class, you may ask me, I'll answer it, or otherwise also you may contact me, or you can contact this number. Okay, you may contact him and he will get you in touch with me. Okay, so if you have no doubts, then you may leave. Okay, thanks a lot. Thanks a lot, guys. You have been wonderful people, and you guys have been excellent students. And I really wish that you will become good lawyers in future and excellent students. Yeah, yeah. I talked about this young person thing, right? Look, there is a what we say. I had written a research paper on it as well. The term child has not been defined anywhere. The term has been used almost in every provision, mm, be it in the form of minor or young person, but they have not defined child. According to Majority Act, if you will read Majority Act, the age of child is mentioned to be below 18 years. Any person who is below 18 years is child. But then we have IPC. In IPC also they have mentioned, at some places they have mentioned 12 years. Then if we come to, like, for section 90 consent, they have mentioned the consent of a person below 12 years is not valid consent. Then if we come to section 361, that is kidnapping from India. No, kidnapping from lawful guardianship. So here they mentioned that the age of male to be 16, female 18. Again, there is a dichotomy here. Then if we come to Article 21A of Constitution, here the age is mentioned to be, like, they mentioned that the state should provide free and compulsory education to the children between 6 to 14 years. Then again, we have Article 45 DPSP of Constitution. The age mentioned there is also different. Let me check. Look, they mentioned 6 years. Childhood care and protection. That's the provision for early childhood care and education to children below age of 6 years. Okay, they are mentioned in Article 45. Also, there is one article, it is either 23 or 24. Yes, it's 24. It basically talks about prohibition of children in factories, and they mentioned the age to be no child below 14 years. So there is now if we come to POXO, the age defined given there is different. If we come to juvenile justice, then the age is maybe 15 years in some cases, 18 years in some cases. So also in IPC, we read about 82 Dolly in Capex. They have mentioned the age below 7 years. Nothing is an offense which is done by a person below 7 years. And then they have talked about a situation of 7 to 12 years in the very next section, 83. Child having sufficient maturity to understand the consequence of his act. So if we see in whole, then the definition of young person is not very much clear. Who is actually a young person or a child? If we come to section 293 of IPC, right? If we come to section 293 of IPC, sale etc. of objects to young person. Here the age is mentioned to be 20 years. They have referred young person as a person of 20 years. Okay, so this is basically a dichotomy here in law. So there is nothing much to be discussed here. The Supreme Court or our Parliament will soon come up with a blanket definition or a more comprehensive definition of young person and child, and then maybe we can have a clear understanding as to who is a child. Okay. Okay. If you have no doubts, you may leave. Thanks a lot. Thank you. Thank you. Yeah. Yeah. Thanks a lot, guys. Okay.